I'm Alex Grant, and this is the Law of the Case podcast for March 6, 2024. Special Counsel Jack Smith and his deputies were probably tempted to start tearing their hair out last Friday when they were working hard to expedite the trial in the Florida classified documents case against former President Trump. At one point in the hearing, Trump's lawyer pointed to the obligations that Mr. Trump had in the Stormy Daniels hush money case in New York State Court. The trial in the Stormy Daniels case was starting March 25th, and it was going to last 6 weeks, and that was going to get in the way of a pretrial hearing the special counsel wanted to have in April in the classified documents case. This was one of the tangible effects of having multiple prosecutions against the same defendant at the same time. There's only one defendant, and he can't be in more than one place. And in this instance, it was the least serious case of the four, the New York hush money case, that was at least potentially delaying a more important case, the classified documents case, from proceeding quickly to trial. And why might Jack Smith and his colleagues have felt more than a twinge of frustration? According to public reporting, the U.S. Attorney's Office for the Southern District of New York, which is part of the Department of Justice, had previously declined to prosecute the hush money case against Trump, even though it had done so against Michael Cohen, the lawyer who paid the money, allegedly at Trump's behest. The New York Times has reported that the U.S. Attorney's Office had doubts about relying on Cohen as a witness. But whatever the reason, a case that DOJ had declined was getting in the way of a case, or maybe two cases, that the special counsel had accepted and indicted. I'm Alex Grant with the Law of the Case podcast. This episode delves into the level of chaos and conflict that is due to these parallel prosecutions against former President Trump. I spent 23 years in the Department of Justice prosecuting nearly every type of criminal case the department handles, and I am currently an adjunct faculty member with the Western New England University School of Law. I am here to give you the straight scoop on the law, and I am unafraid to tell you when the emperor has no clothes. This podcast will cover the legal issues that journalists miss because they have never stood up in a courtroom, and I explain the law without carrying the water for either political party. The problem of parallel proceedings is not unusual in federal criminal prosecutions. When I started at DOJ, I did healthcare fraud cases, where you would often have potential federal criminal charges, federal civil charges, federal administrative charges, as well as potential criminal and civil charges from one or more states. When I was prosecuting online sexual predators, you often had federal crimes for their online behavior and state crimes for their hands-on real-world behavior. Those are just examples of parallel cases, meaning cases that are open at the same time against the same defendant or group of defendants. And they can happen in other areas, like prosecuting a former president. When you have multiple cases, you have multiple decision makers, heads of U.S. attorneys' offices, DOJ headquarters, district attorneys, state attorney generals, and more. And with multiple decision makers, you have multiple egos, potentially multiple agendas, multiple cases of varying strength based on the facts of those cases and the laws in the different jurisdictions. So it can be tricky to work these things out. In a criminal prosecution where a defendant is being held in jail before trial, it gets even trickier because the defendant has the right to be in court while important hearings are taking place, and it is just not possible to move a defendant from one jurisdiction to another quickly. Practically speaking, that means these multiple cases have to wait in line and happen one after the other. With Trump, he's not being held, but as I say, it's still tricky. So that leads to the question of who gets primacy. Who is the lead dog? In the ordinary case, it is up to lower-level prosecutors to negotiate these issues, and it often comes back to who charged the first case. But with big national-level importance cases, it is DOJ that typically takes charge. Take a case like the prosecution of Zacarias Moussaoui, the 9/11 plotter. You could have had multiple state and local prosecutors trying to bring cases for deaths and injuries caused in their jurisdictions. Instead, you had DOJ calling the shots from day one, and there was one big federal criminal trial against Moussaoui that resulted in his conviction. In a less noteworthy case, you might have had multiple U.S. attorneys' offices within DOJ jockeying to bring their respective cases. But it was clear in this massive 9/11 case against Moussaoui, there was a strong hand at DOJ making decisions. Another instance of this strong hand was when I was living in Washington, D.C., in the D.C. sniper case. You had John Muhammad and a less culpable teenager he had recruited going around the D.C., Maryland, and Virginia areas shooting innocent people from hidden positions. It was awful and terrifying to an entire region. I should note that I was not involved in either the Moussaoui or the D.C. sniper case, but the public reporting made it clear in the D.C. sniper case that the federal prosecutors had primacy, and they decided that Virginia, with its death penalty, should go first, even though other local prosecutors were griping that they should be the lead dog, that their local murder cases should go first. So why is primacy important? First of all, you have the basic question of scheduling. Just think that every case is a long list of deadlines, a series of sequential steps, events in court that must happen in a certain order to get to the central event, which is the trial. As we have seen with the Trump cases, each case is like a long train, and those trains can bump into each other if they are all trying to get to the same place at the same time. The same lawyer is often involved in more than one of the defendant's cases. If that lawyer is working on one case, that same lawyer cannot be focused on another case. And the defendant himself is also part of the defense team in every case. And time that the defendant spends preparing for one case is time he cannot spend on another. And on the government side, some of the investigators may be working on more than one case involving the defendant, and time spent on a trial in one case means the investigator is out of pocket for a while on everything else. So that means you need a decision maker to decide what should go first, what should go second, and so forth. To the extent there are trade-offs to be made between the interests in the respective cases, you want to be clear what those trade-offs are, and do they make sense? Let's say in the DC sniper case, or in one of my sexual predator cases, you had a traumatized victim who was a witness. That witness might only have the emotional strength to get through one trial and not several. So somebody needs to decide which trial that witness should testify in. Now take Trump's Georgia election interference case and the federal January 6th case brought by the special counsel. There's some overlap there. If you have witnesses who are going to testify in both cases, the witness's testimony in the first case could be used to impeach the same witness in the second case if there's any inconsistency between the two testimonies. Maybe the government lawyer in the first case does not prep the witness very well, and the witness forgets some things. Well, that is going to come back and bite the prosecutors in the second case. Between those two, the Georgia case and the federal January 6th case, the defense lawyers in the second case are going to have an easier time of it. It's like the first case is a preview of the second. The other reason for primacy is for someone to be looking at the big picture so that the strongest case goes first. That means the strongest in terms of the evidence, the strongest in terms of the law being already settled, and the strongest in terms of the moral clarity of the case. That last part is important. Even when the facts and the law fit, a jury may not convict if the result does not seem right or does not seem moral. Why does it matter that the strongest case go first? In a more ordinary situation, putting an ironclad case first may lead the defendant to decide that winning is impossible, and the defendant may decide to plead guilty in a package deal. As a criminal prosecutor, my goal was to investigate the case so well, to amass all the evidence so well, to be so right on the law that I could not only convince a 12-person jury, but the defendant himself of his own guilt, so that he would conclude that pleading guilty was the best course. With Trump, there are so many other interests, political and emotional, that it looks like he will never plead guilty, at least in the first instance. But even in that case, you want the strongest case to go first. If the defendant loses that first case, his mindset is apt to change from denial to wanting to mitigate his losses. He may decide that taking responsibility and making amends will put him in the best position in the sentencing of the first case, and he may well decide to plead guilty in the others and seek concurrent time. In other words, to run all the sentences together instead of having them stack on top of each other. On the other hand, a defendant's victory at that first trial will validate all of the defendant's denials about his guilt. The public, which includes members of the jury pool for later trials, may conflate all of the cases together and see the acquittal in the first case as proof that none of the prosecutions are valid. Trump is trying to send that message already, that all of the prosecutions are witch hunts, and any validation of that narrative through an acquittal or even a hung jury will cause Trump fans to double down on his denials and cast him in the role as a victim of overzealous prosecutors. This is probably the biggest parallel criminal prosecution ever. And as I say, DOJ is well versed in managing parallel proceedings. But Jack Smith and the state prosecutors are not following the usual DOJ playbook, where DOJ is the quarterback, looking at the overall interests of the public and how to achieve the best result for the public, and deciding on the priority of the cases. Under the DOJ playbook, that does not necessarily mean having the federal case go first. It could mean having the state case go first. In civil rights cases, for example, it is DOJ policy to allow the state prosecution to go first, and then only have a federal prosecution if there is a significant federal interest that is still not met. In the Trump prosecutions, it appears there was no plan for prioritizing the order of the cases. That is why things are happening almost by chance. The New York hush money case was the first case charged and was waiting in the wings for a while. The January 6th D.C. case was scheduled for trial first on March 3rd, but then that date got pushed because of the presidential immunity appeal. So that opened up a slot in former President Trump's calendar So voila, the hush money case gets scheduled for March 25th. Having the hush money case go first seems like a really bad idea to me. First of all, the public interest in pursuing this is quite low. This goes back to 2016, and the public knew about Stormy Daniels when they elected Trump in November 2016. So it's not like there's any news here. And the crimes of Trump falsifying Trump's own business records, it's hard to see who exactly was the victim. Of any of the cases, if there is a jury which would acquit, or a single juror who would hang the case on the basis of the case seeming to be no big deal, this would be it. Remember we had a national conversation in 1998 about lying about sex under oath? And for a lot of people, the verdict was, well, everybody does it, and this should not be prosecuted. Things have changed since then, but maybe not enough to help Alvin Bragg. The trial in the hush money case seems like better than even odds for Trump. If he is convicted, he's unlikely to be sentenced to jail time, and a conviction in that case is the easiest to slough off to voters and his business partners. I think the affair with Stormy Daniels has already been priced into Trump's reputation. On the other hand, if he is acquitted or he gets a hung jury, he will trumpet that result as complete vindication. A win for Trump will help him much more than a loss will hurt him. Now, I'm going to be doing an episode on a particular aspect of the hush money case that has been ignored by the news media, which has treated the case as a virtual, albeit small, slam dunk. But I will tease that episode just by saying that proving Trump's criminal state of mind will not be an easy task. The New York prosecutors are going to have to do much more than prove that Trump paid off Stormy Daniels to stay quiet. But whatever you think about the strength of the New York case, you have to admit that there is a lot to lose and not a ton to gain. Imagine if Trump wins or gets a hung jury, and that is the only verdict or result in any of the 4 prosecutions before November. I think at that point, all of these cases would be a net positive for Trump's campaign. At this point, I hope I have convinced you that A, there is no overall plan, there is no quarterback, and B, the way this is unfolding is not a very sound prosecution strategy in a parallel prosecution. So why is this going on? First of all, it has been publicly reported that the 3 prosecutors, Jack Smith, Alvin Bragg, and Fani Willis, have not communicated about their respective cases. That is probably to fend off complaints that they are coordinating and to fend off conspiracy theories on the part of the Trump crowd. In order to have a rational, parallel prosecution strategy, communication has to happen. That is basic. And prosecutors can be open about it. There are certain lines that prosecutors have to respect. For example, you cannot use the civil process as a stalking horse for a criminal investigation. But in the case of different criminal prosecutions in different jurisdictions, it's fine to communicate. And you could even get everyone in a room to decide on a global plea deal to present to Trump. I don't think that is going to happen, but the point is you can talk and you should talk. Second, in addition to communicating, it is best if the respective prosecutors have a shared goal. Using my example of the sexual predator being prosecuted in federal and state court, the shared goal is probably going to be taking him out of society for a very long time and sparing the victim of the need to testify, if possible. So if you have communication and shared goals and put egos aside, parallel prosecutions can work just fine. And when I say put egos aside, that means putting what is good for the case first, what is good for the overall public interest first, achieving a good result first, and being okay if you are not in the spotlight, and being okay with not getting the credit. To give you an example of how a personal agenda can get in the way of things, we had situations where somebody would get caught with a bunch of child pornography, hundreds, thousands of images and videos of the most vile stuff, the kind of content where you think this guy really has a sexual interest in children and may act on it. The DA's office might charge that child pornography case, and under laxer state laws, the defendant might get sentenced to probation or a year in jail, putting him in a position to reoffend. But that district attorney will be the one to be able to say he prosecuted the case. He can issue the press release. He can have the news conference. Now, if the DA referred that case for federal prosecution, there's a federal statute that would give that defendant a mandatory 5 years in prison. Better for the public, and the district attorney would be thanked in a press release from the U.S. Attorney's Office. But that's not as good for the district attorney's next re-election campaign. So sometimes the need for prosecutors to get credit can lead to a worse result. So looking at the Trump cases, you have two elected district attorneys who have an interest in being seen as getting tough on Trump. And it's that personal agenda that helps explain why Alvin Bragg would go forward with the hush money case that his predecessor was not willing to prosecute. So even if you had communication among the Trump prosecutors, it would be hard to put egos and personal interests aside. And finally, do they all have a shared goal? Yes, they probably do. All three prosecutors want to hold Trump accountable for his conduct, and they want to convict him before the election. But the problem is that there is not enough time to conclude 4 complicated cases with millions of pages of documents and thousands of hours of video all before November. Throw in some complicated legal issues like the issues I talked about in my last episode, presidential immunity, in the scope of the federal obstruction of justice statute. It's like trying to solve a Rubik's Cube for the first time. You can get it done, but it won't be fast. Situations like this call for a strong quarterback to set the agenda and to call the play. Normally, that is DOJ headquarters, going all the way up to the Attorney General. But here we have a special prosecutor who is nominally in the line of authority to the Attorney General, but because he is special counsel, Jack Smith is not taking his day-to-day orders from the Attorney General. And Jack Smith does not have the political stature that the U.S. Attorney General has. So even if there was communication and the prosecutors were trying to coordinate, Jack Smith would have a tough time trying to gain primacy over 2 political actors like Alvin Bragg and Fani Willis. The result is that you have 4 cases, each marching to the beat of its own drum. The prosecutors have a shared goal, but there is no shared sense of how to accomplish it. If you had agreement on the goal and agreement on the means to achieve that goal, here's what you would do. You would have cleared the decks of everything except the strongest case. 1 case, 1 defendant. No distractions, no calendar conflicts, just focus on that single strongest case. The case that has the fewest open legal questions, the case with the most straightforward facts, the case that has important stakes. Among the 4 Trump prosecutions, none of them fits the bill exactly. But the classified documents case probably comes closest. It matters more than the hush money case, and it is less complicated legally and factually than the Georgia case and the federal January 6th case. Those latter two cases take on more serious conduct, but there are a lot of complications with them. If we were playing Monday morning quarterback, it's easy to say that waiting to indict these cases until 2023 gave us this time crunch. But there was a reason why these cases took as long as they did to investigate and to indict. The Department of Justice, I think you can infer, had some doubts about the federal cases. And because the federal January 6th case and the Georgia case were complicated factually, with hundreds and thousands of witnesses and the cases hinging on the truthfulness of claims about an entire national election involving over 150 million votes cast, there was a lot to do to investigate. But problems like these are not problems of tactics. Those are challenges that even coordination and communication cannot solve. So yes, there is a problem with having nobody quarterbacking these cases. Even with the best leadership, you would still be in the Supreme Court hashing out some unresolved legal issues. You would still have to be fighting off claims of selective prosecution because President Biden retained his own classified documents. You would still be managing a massive amount of evidence and material. But if you had a quarterback, you at least would not be worried about payments to a porn star taking over the prosecutorial agenda and delaying more important cases. If you want to keep learning about the stuff that traditional media sources leave out or get wrong, subscribe to this podcast. You can also find the podcast on Twitter at Law of the Case Pod, on Facebook, on YouTube, and you can email the show at lawofthecase@gmail.com. Until next time, I am Alex Grant for the Law of the Case podcast.